So good afternoon, everybody. Again, thank you all for joining us this afternoon. My name is Peter Kempner. I am the legal director here at Volunteers of Legal Service, also known as VOLS. We are having this lunch and learn today to focus on housing issues. I'm sure everybody is well aware that one of the most pressing legal issues that New Yorkers with limited resources relates to housing. There are sadly so many New Yorkers who are facing eviction, are living in substandard housing conditions, face harassment by their landlords, and so this really is one of the greatest legal needs of New Yorkers with limited resources. We work with schools and healthcare providers in low-income communities through our Children's Project, where many of our volunteer attorneys deal with clients, help clients who face housing issues all of the time. And so we've set up this session to be able to highlight for our volunteers and for other pro bono attorneys some of the important questions to ask when talking to low-income clients with housing needs. It is critically important for us to be able to identify the types of housing that our client lives in, what they're facing with respect to any court proceeding, what their possible defenses are, and what resources are available to them in the community for assistance. So that is the focus of this lunch and learn today. And again, thank you for joining us. I'm going to turn the mic over to my colleague, James Fenton, who is the Senior Staff Attorney for Housing Rights and Special Populations here at VOLS. So Jim, take it away.
Thanks so much, and thank you all for joining. We're going to be focusing today's training on how to do a housing intake in New York City. It's not going to be an exhaustive housing practice training, because that would frankly just take way too long. If you are taking cases for full rep and those questions come up, feel free to reach out. Always happy to talk housing. The reason we want to focus so heavily on intakes is because housing law in New York is a fairly complicated kind of mess of overlapping statutes and case law and government programs. And the questions you have to ask and the information you have to gather isn't necessarily self-explanatory. So I think this will be helpful. So here's the agenda for today. I'll start with some introductions. As Pete said, I'm Jim. I work with the Children's Project answering housing questions. Before coming to VOLS, I spent about 5 years at UJC as a eviction defense housing supervisor. So I have some experience in this. I'm a little rusty now. Things changed pretty quick during the pandemic. So during the Q&A, if you guys have more recent experiences you'd like to chime in with, I would love to hear about them, and always love to hear what's going on the ground. So brief overview, we're going to first go over just what is the basic information you have to collect as part of every housing intake. Then we're going to get into more specifics on how do you determine what housing type your client is living in, determine the case type that they're going to be dealing with, determining the procedural posture of that case, and then we're going to get into some issue spotting and finding potential defenses so that you can give your clients advice on the next steps and where this might be going. And then, like I said, we'll have time for questions. So just a brief overview of information you should be collecting. First is names, and I hope it kind of goes without saying that you'd be getting the name of the person that you're doing an intake with, but combining that with the next one, number of people in the apartment and adults versus minors. A landlord actually has an obligation to name every adult who resides in a household that they know or reasonably should know the name of. So you actually do want to get a little bit more involved than just the name of the person you're talking to. You're going to want to ask how many adults are in the house, what are their names, does the landlord know who they are? Who is the person paying the rent, whose name is on that check? Who is the person asking for repairs when those need to be made? Is there a super in the building or an agent of the landlord who everyone's interacting with? And you're also going to want to know people's relationship to each other as a way to look out for conflicts of interest. I can't tell you how many times I have 2 or more people come to me and say, yeah, we're family members, we're best friends for life, whatever the case may be. We're sticking together, and then a landlord makes that offer of, I'll let one of you stay as long as the other person leaves. And then if you're representing both of them, suddenly you've got a conflict on your hand. So not just the name of the person you're talking to, but the names of everyone in the household, what their relationships to each other and the landlord are. The next thing you're going to want to determine is the lease status. Is there a lease in effect? Is it a written lease? Is it a verbal lease? Is it just a years long, multiple years, month to month? Is it just a handshake deal? And then who is the lease between? Is this the person you're talking to? Do they rent directly from the building owner, or are they a subletter? Are they a roommate, and are they not even on the lease? You want to know when does the lease expire and whose name is on it. The next question is, what type of housing? Some clients will know right away, yes, I live in a co-op, I live in NYCHA, I live in a rent stabilized unit. Other clients won't necessarily know what type of building they're in. So a little bit later, we're going to get into what kind of questions you should ask to determine that. I will also say it's worth asking those questions, even if your client seems pretty sure, because landlords are not always honest about what type of apartment it is, especially if being honest will cost them money. So it's good to ask the kind of follow-up questions to come up with your own understanding of the situation and your own answer to that question, even if your client is saying, oh, it's just a market rate apartment. Another big question is there already a court case? If there is, from an intake perspective and from a legal service perspective, that's sort of a mixed blessing. It is bad because obviously it's bad when any of your clients are being sued, and that will accelerate the timeline of your involvement and the urgency of the situation. The upside is that now Housing Court has converted to e-filing, and so most case files are available online. So if there is already a Housing Court case and your client knows the index number, you can probably pull up the whole case file right as you're sitting there talking to them, and get a better idea of what's going on. That's a recent pandemic onward development. Housing Court used to be all paper files and wasn't available online, so that is sort of a huge advantage now to doing these intakes. Whether or not the case is court involved, you're going to want to know what the procedural posture is. If it is court involved, is there a judgment, or pre-judgment or post-judgment, is one of the most important questions in housing practice. It makes everything look, could make the entire scope of your representation look entirely different. And if it's not court involved, what documents have your client received? We'll get into this in a little bit more specifics later. I think this is important because I think pretty much every client I talk to says, I've received an eviction notice, and that could mean any number of documents. And so knowing exactly where they are in the process is really helpful to knowing what advice to give them on next steps, and also knowing how much time they might have before hard decisions have to be made. If the client is already court involved, or if they've already started receiving court notices, even if they haven't been formally sued yet, you're going to want to determine what type of case is pending against them. Again, we'll go into a little bit more specifics about case type later, but there is a range of different cases a landlord can bring, which have entirely different consequences for the client, and which might take place in entirely different buildings or forums. And so you want to know that, even just to know where to send them for the next step. You're going to want to know, does the family receive any benefits, and what kind of benefits those are? Is there a rent subsidy that helps them pay their rent? Do they receive cash assistance, any form of public assistance? Getting those amounts is helpful. Oftentimes people are receiving the incorrect amounts from public assistance. And while I think it's rare that that fix will get them totally out of arrears, it definitely helps if you can, get somebody more money than they're currently receiving, if that's what they're entitled to receive. And then finally, I don't think I needed to really put this on the PowerPoint, but I didn't want to get anyone, including myself, in trouble. Any other eligibility or reporting information your firm requires, data collection and retention and reporting is important. Please get that. Don't ignore boxes on the intake forms that you've been given just because they didn't come up in this training. All right, so we're going to get into determining housing type, and we're going to start with why is this information important? Depending on what type of housing your client lives in, there's any number of different rights and obligations they might have as a result of that. Additionally, what kind of housing they live in might determine which venue their case is going to be heard in or which venue they can seek relief from. For example, rent stabilized tenants can pursue claims at DHCR. DHCR has no jurisdiction over non-regulated apartments, and so those tenants can't appeal there, and that's a whole category of advice that would be off the table in certain cases. Additionally, housing which is government monitored has oftentimes their own processes before you can get into housing court. We're going to talk a little bit more specifically about NYCHA termination hearings. But in Mitchell-Lama cases, if you're applying for succession and the development denies it, you can appeal directly to HPD or DHCR. And there's a whole range of due process that you're entitled to at those venues before it gets into court. Landlords might also be entitled to give those government programs notice or even implead them as part of a case in housing court. And so knowing what the housing type is just incredibly important. Can't overstate it. That's why we're leading off with it. So we'll start off with rent regulated buildings. Any building built prior to 1974 containing 6 or more units is presumably rent stabilized. And I'll stop here and mention the distinction between a rent stabilized building and a rent stabilized apartment. A building that is presumably stabilized and which most of the apartments are stabilized may still contain unregulated apartments. Between 1993 and 2019, apartments could be removed from rent stabilization for meeting monthly rental criteria called luxury deregulation. There's also substantial rehabilitation laws that can take an apartment from stabilization. So your client may be living in a presumably stabilized building. It might show up on the list that they publish, but their apartment may still be unregulated, and vice versa. Rent stabilized buildings are able to be converted into co-ops, and when that happens, renters are given a choice whether to buy into the new co-op or remain rent regulated tenants, rent stabilized tenants. And so your client might be living in a building that seems to be a co-op, but they may still be a rent stabilized tenant despite that. So something to keep in mind, it's the actual apartment that is important, not the building itself. Like I said, some tenants may know right away, yes, I live in a rent stabilized apartment. Others may not, and others may have been told they don't when in fact their building should legally be stabilized. So some follow-up questions that you should be asking are, how old is the building and how many units? You can look up generally on ACRIS or Department of Buildings, which we'll get into a little later. You can see the actual age of the building and see if it was built prior to 1974. Units, I'm going to make another distinction too. For the purposes of the rent stabilization code, it's not just legal apartment units that count towards the 6 or more. Illegal basement apartments that violate the C of O count towards that. Illegally subdivided apartments into SROs or multifamily units can count towards that. So it's important to not just ask how many apartments are in the building, ask some follow-up questions, get a little more detail. Sometimes a client will say, well, it's, I rent the whole first floor. I think there's like 3 families on the second floor, and I think there may be 2 families in the basement. Even if you're going to want that kind of specificity, you're not just going to want them to say, well, it's divided into 2 floors with a basement, because that could count towards it possibly being stabilized. Another way to determine is to ask what the monthly rent is. In general, if there's a weird, odd, specific number like 1963 and 74 cents, it's probably rent stabilized because yearly increases are taken as a percentage of the existing rent. If it's an unregulated apartment, the landlord's probably just going to charge an even $2,000 instead of going into that kind of minutia. That's not a hard and fast rule because a rent stabilized tenant could be offered a pref rent that comes in at an even number. Could be just a coincidence if it was an even percentage year. It might have synced back up. And of course, unregulated units are landlords are free to charge whatever they want. If they want to charge 1963 and 74 cents a month, there'd really be nothing stopping them. So it's not a hard and fast rule. But in general, I would say if there's a weird rent number like that, it's probably stabilized. And if it's an even number, it's probably unregulated. Another question is, do you get a renewal every year? Rent stabilized tenants are entitled to a yearly renewal, whether the landlord wants to give it to them or not. Unregulated units, the landlord can cancel the lease and decline to renew that tenancy for any non-discriminatory reason. So if again, this isn't a hard and fast rule. Some unregulated landlords will just automatically send out those renewals. They're not looking for much turnover. But other times, if if your client says, yeah, at the end of every year, it's hard, drawn out negotiations with the landlord, it's probably unregulated. Rent stabilized landlords generally know to just send the renewal. How much has the rent increased in the past? If they say it's been the same for 10 years, it's probably rent stabilized. You don't see that happen often in market rate units, but again, not a hard and fast rule because unregulated units are allowed to do whatever they want. And then an actual hard and fast rule is, is the house on SCREE or DREE? Department of Finance offers rent freeze programs for seniors or disabled tenants. And they are sticklers about only giving those to actually rent regulated units. So if someone in the household's on SCREE or DREE, it's definitely regulated. So like I said, the benefits to it being a rent stabilized apartment is that your client is entitled to a renewal, whether the landlord likes it or not. The amount that the landlord can take as a yearly increase is governed by the city. And leases are governed by the rent stabilization code, and you are actually not allowed to sign away your rent stabilization rights, even if it somehow would work in your benefit. Therefore, there's no, with limited exceptions due to other government programs, no sneaky rider or sneaky lease language that you have to worry about. Your client couldn't sign those rights away even if they wanted to. Rent control units are important to mention. They're few and far between. I've actually seen more here at Vols than I did, I think, in my 5 years at UJC, since our practice is more geared towards seniors, and that's who's left in them. I want to say there's like 300 left in the city or some remarkably small number like that. Rent control tenants are statutory tenants. They don't receive yearly lease renewals. We're not going to get too deep into the rent control laws because there's just so few of them left. I think it's rare that you encounter them. If you do, we'd love to hear about it. We'd love to hear questions on it. Buildings can also be rent regulated via an agreement with the city. And for that, you have to check ACRIS, which is the Department of Finance's basically like deed reporting system that's available online. The way that this happens is a landlord can borrow money from the city, which comes with strings attached and provides additional rights to the tenant. Generally, they fall into different pre-existing affordable housing programs, like the low-income housing tenant tax credit program, the 421A program. And so usually when you see these regulatory agreements in ACRIS, you can pretty quickly determine what program the building falls under and get a pretty good idea of what kind of rights your client may or may not have. But theoretically, I guess the city's housing development corporation could negotiate something specific with some landlords. So it's important to read those regulatory agreements in their entirety and not just read the top line and say, oh, I'm familiar with this program, I can move on. Plus, they're complicated, dense agreements. You may find something that isn't immediately apparent if you take the time to read it. So definitely encourage everyone to read every regulatory agreement fairly thoroughly. The other big types of housing, public housing through NYCHA. This is probably the one that has most disparate treatment from every other tenants in New York City. To begin with, when a non-NYCHA resident calls 311 to complain about repairs, they're routed to HPD, who can send inspectors that can place violations on the building and eventually levy fines against the landlord for not making repairs. NYCHA tenants are rerouted into NYCHA's internal work order system, which is notoriously unresponsive and terrible, they'll call 311, they'll generate a work order, and that triggers somebody to leave a "we were here and you weren't home" notice on your client's door without ever knocking generally. Additionally, there's all kinds of internal processes at NYCHA that they have to follow before they can get into housing court, or that you can maybe redirect a housing court case towards. And so that's important to know if someone lives in a NYCHA building. There are also project-based Section 8 buildings. These are generally privately owned but governed by Housing and Urban Development. And so the HUD handbook determines the rights and obligations that your client enjoys in those buildings. There's supportive housing units. And this is another one where the building type and the apartment type may be different. Some full buildings are supportive housing buildings, and every tenant is bound by those rules. Other times, supportive housing providers will rent an apartment from a private landlord. And so your client may be in a supportive housing unit, even though they're in just a regular rent stabilized or market rate apartment somewhere else. In general, your client won't be on the lease if that's the case. It will be the supportive housing provider that is the listed tenant, and that can create all kinds of problems later on down the road. Co-ops and condos. With co-ops, generally, whatever the board votes on and whatever's put into the bylaws and the initial lease is fine and will be the governing law of your case. Pretty much the only pushback you have on that are general contractual principles. They can't put anything illegal or unconscionable or impossible into their bylaws. But beyond that, if the board votes on it, your client is stuck with it. A specific thing to be aware of before you get into determining the case strategy with co-ops is most bylaws have something about a presumption of attorney's fees in cases. And so that's something to keep in mind, because you may tell your client, well, yes, we can go for an abatement, but you're probably going to pay their attorney's fees, and the abatement may not offset that. And that might understandably impact the strategy your client wants to take. And then finally, all other buildings, market rate buildings, again, very little protection for tenants in an unregulated building. Landlord can decline to offer a renewal. They can charge pretty much whatever they want. They have to give notice if it's exceeding a certain percentage in any given year, but there's nothing, as long as they give that notice, there's nothing barring them from doubling or tripling the rent. And so important to keep a lookout for those. Great. So we're going to move on to determining the case type, and the different types of cases that we're going to be talking about are non-pays, holdovers, HPs, NYCHA termination hearings, illegal lockout cases, and ejectment actions. So we'll start with non-pays. This is just very simply an action to recover possessory rent commenced after the serving of a 14-day rent demand. In order to have a non-pay, which all actions in housing court are summary proceedings, they're not full-blown trials, so everything happens much quicker than it would happen in, say, Supreme Court or general civil court. And landlords have to follow certain prerequisites to getting into court in order to avail themselves of that benefit. We'll get into some specifics when we talk about finding defenses later. But the big one to know is that it's a 14-day rent demand. It can only be possessory rent is what the housing court has jurisdiction over. So if, outside fees, late fees, those kinds of things can't be collected in housing court. So if that's the only thing your client owes, you'll probably end up with a civil case instead of a housing court case, and they want us to worry about being evicted for it. And there has to be an actual contractual relationship between the landlord and tenant. If not, the correct remedy is to bring a holdover. And so holdovers are an action to recover possession of an apartment for reasons other than failure to pay rent. Holdovers are commenced after serving of predicate notices, which are a notice to cure and or a notice of termination. Depending on the theory of the case, they either have to give an opportunity to cure before sending that notice of termination, or in specifically nuisance cases, you can jump right to the notice of termination, or in licensee proceedings, jump right to the notice of termination and don't have to give that opportunity to cure. It's important to know the difference between the two, because I can't tell you how many times clients have come and say, my landlord's suing me, I don't get it, I pay rent on time every month, and you have to explain to them, this case has nothing to do with paying rent actually, and in fact, you may want to stop paying rent because the landlord doesn't want you here anymore. There are different types of holdovers. Again, there's in unregulated units, there's we just want you out, and we call those no defense holdovers. There's not a lot you can do about it. In rent regulated units, it's generally for some kind of objectionable behavior that they're alleging, or it's because what's called a licensee proceeding. That's where somebody moved in with permission of the named tenant, and that permission has expired either because that named tenant moved out or passed away, and now the landlord is suing the person who's remaining there directly. In HP, that's just short for housing part. This was the original housing court case. It is where a tenant sues a landlord to get repairs done. It's generally commenced by OSC. The court imposes fines for violations of the Housing and Maintenance Code and sets a timeline for those repairs to be completed. A big thing to remember is that a tenant can't be awarded monetary damages in this kind of proceeding. You can negotiate for an abatement as part of a settlement of an HP case. A landlord may be willing to do that to make the case go away faster and save some attorney's fees, but that's not a relief that the court can actually award. HPD is a party to these HP actions. Court will generally order an HPD inspection as like part of the first court date and then adjourn it for some follow-up later. But I always advise the client to call 311 and get their own inspection even prior to starting it. It can streamline it, and it also may be enough to get the landlord to do the repairs even without having to go to court. These cases generally can be commenced pro se. There's a fairly easy fill in the blank form that the courts offer. But if if they have the assistance of an attorney, all the better. Illegal lockouts. So illegal lockouts are filed if a landlord or roommate uses self-help, which is basically changing the locks without a city marshal. That is the sort of overarching protection that every tenant in New York City has. I think a lot of people confuse this with squatters' rights. Squatters' rights really aren't a thing as most people understand them in New York. But if a person resides in a dwelling for more than 30 days, a landlord can't just come in and change the locks themselves. That person is entitled to judicial process. They need to go to housing court, get an order of eviction, and have the marshal come and change the locks. If they do it in any other way, you can file an illegal lockout. These are fairly urgent when you run into somebody that's been locked out of their apartment, obviously. Again, this is something that can probably be commenced by the tenant, and it may be faster to advise people to just run down to housing court and do it themselves than to wait for them to clear conflicts and all of that. They're commenced by OSC. And if you are drafting a petition yourself, you want to make sure that you include as part of the interim relief in that OSC that the contents of the apartment don't be tampered with or removed, that no one else is allowed, that the landlord is not allowed to relet the apartment, and supervised interim access prior to the return date. Because generally, if someone's locked out, I certainly don't leave my apartment with a copy of my lease or a copy of my water bill every day. If my landlord chose to lock me out, it would be kind of difficult to prove that I live there without getting into the apartment first. So you're going to want to make sure that you include that as part of the interim relief in the OSC. And then a really tough piece of advice that you'll have to give clients in this situation, but that I think is really important, is that they do take a few days. Generally, like I said, the court will sign an OSC and then give a return date of about 2 business days after. So you'll have to advise your client to make temporary housing arrangements. It's very unlikely that they can be let back into the apartment to sleep there the same day. So landlord can also sue in civil court for non-possessory rent charges, or may bring an ejectment action in New York State Supreme Court. The civil court for non-possessory rent charges, we're seeing a little bit more of. Landlords, want those legal and late fees more now. There's also, we'll get into in the defenses section, the Tenant Safe Harbor Act made a bunch of pandemic money non-possessory. And so that's no longer, most landlords won't try to get it in housing court if they're fairly certain it's that it's not going to be possessory. They'll go to civil court where there is no right to counsel and they can proceed against a pro se tenant. So I would say you didn't see a ton of landlords in civil court a couple of years ago. Now, most landlords firms have like a bureau or a couple of attorneys that practice in civil court for non-possessory money. So that's the thing you might run into a little bit more these days. Ejectment actions in Supreme Court are fairly rare. I've only seen them in cases where nuisance cases where the alleged conduct is fairly severe. That's because they can be commenced by OSC, and then the landlords generally try to turn around a contempt motion for violating that initial order fairly quickly. And again, there's no right to counsel in Supreme Court, so landlords may take that option specifically to avoid having to litigate against a tenant with an attorney. And then I forgot to make a specific bullet about NYCHA termination proceedings, but I do want to talk about those specifically. In a licensee case, if the named tenant in a NYCHA apartment has moved out and there's just family or friends remaining, or in a case where there's alleged misconduct that violates the tenant's lease in the NYCHA handbook, NYCHA will bring a termination hearing. They do different steps of their grievances for remaining family member grievance, which is what a tenant has to bring if they want to have succession rights to the apartment. They have to start at the building level, then the borough level, and then eventually go for a hearing at NYCHA's hearing office. Same thing with a termination proceeding. They'll serve the predicate notices, then they'll bring you in for a hearing at their hearing office. A lot of times attorneys, you don't need to be represented by an attorney at that hearing. You can be represented by an advocate, paralegal, anyone you want to bring, or you can proceed pro se. So a lot of attorneys don't take them as seriously as they should. But that's really where the battle is won and lost in most NYCHA cases. If a NYCHA hearing officer, okays a termination of tenancy, they're basically only going to housing court to get that decision rubber stamped and get a judgment from a judge. And it may be too late to fight it, or it may be way more complicated to fight it at that stage. So if your client comes with a notice from NYCHA, that should be taken as seriously as if it's a notice from the housing court. So important to keep that in mind. So now we're going to talk a little bit about how to determine the procedural posture of a case, if it's court involved or if it's pre-court involvement. So I'm going to do a quick timeline of the notices and court papers that your client might receive. Starting off with a fair debt collection action notice. This is basically under federal law. Anyone who's trying to legally collect a debt has to give 30 days notice, informing the person who they're collecting the debt from that they're an authorized debt collector, and giving them that 30 days to respond in writing to ask for clarification and further information about the alleged debt. Rent debts fall under that, and landlords' attorneys who want to collect that debt in a non-payment or even as use and occupancy in a holdover have to serve this notice. In general, I would say I used to see these just kind of sandwiched and combined with the 14-day rent demand, and landlords' attorneys would generally just include that language as part of their rent demand. I've had a number of clients call me recently and say that they received these notices prior to getting the rent demands. So I just wanted to throw it in case you see that. You may see it 16 days before the 14-day notice so that they get the full 30 days before they commence proceeding. But if your client receives that, they're probably getting the next one, which is a predicate notice. And again, that's a 14-day rent demand for non-pays. and a notice to cure and or notice to terminate for holdovers. In the spotting defenses thing, we'll get into the specifics of what has to be in those notices, but just know that if you get those, that's the precondition to filing a petition in housing court or Supreme, whatever venue the landlord is going to go to. Once you get the notice of petition, if it's a holdover, it will come with a date on the calendar for your client to respond to. If it's a non-pay, it will give them 10 days from whatever day they receive it to go answer at housing court. So if it's a non-pay, you should advise your client to go down and file a pro se answer. It's better to do that than to default. If you decide to take on representation later, or if they're assigned a right to counsel attorney later, they can always make a motion to amend that answer to include any defenses the client wasn't aware of at the time. So definitely better to go than to collect a default. And clients may have received different information during the pandemic. So that may be a point that you have to clarify. During the pandemic, they weren't collecting defaults. So it was actually better in most cases for tenants not to answer the petition, because it would basically just go into limbo and wouldn't be put on the court calendar. Now defaults are back and you don't want to have to deal with them. So the smart advice is to tell clients to go down to housing court and answer. After that, there's any number of court papers they might receive. There may be motions that the landlord is seeking to make. The court sends a number of index cards as reminders for each court date. That can freak some people out. And then eventually the final notice that people will receive, and this is the really important one, the really scary one, is a 14-day marshal's notice of eviction. That is if your client has a judgment of possession against them and the marshal plans to actually come and evict. This is the one that should trigger all the alarms and all the bells and whistles, because you have to act very quickly in these situations. And only a court can stop a marshal's notice of eviction. There's no like demand letter you can write to get them to stop. You can try, but only a court can actually stop them with any kind of finality. As I mentioned at the top, if a case is court involved, you can just search the case on NYSEF or in eCourts to get either with the index number or the tenant's name to try and get an idea of where it is in this process. The NYSEF is fairly reliable, I would say, but doesn't show upcoming court dates necessarily. eCourts, on the other hand, does show upcoming court dates, but is much less reliable. If a case has been marked off calendar for whatever reason, it won't show up in eCourts anymore. The case file will still be available in NYSEF, so you can search it there. But there are definitely gaps in this information, and so I wouldn't trust it 100%. It might be worth a call down to the housing court to confirm, but in most cases you can get the information online. Great. So I think we're going to move to the finding defenses portion, and we're going to be talking a little bit more specifics about all of the stuff that we talked about ahead on the first half. So first of all, in any kind of housing case, and I think pretty much any legal case in general, traverse is the defense to look for. Was the client served properly? And so you should get specifics of how each document was alleged to be served, how your client received them. And again, this is where the who lives in the apartment comes in handy too, because if the description of who the process server allegedly served court papers on doesn't match anyone who lives in the apartment and is somebody, obviously the neighbor next door, that's important to know. Another defense that is applicable in every case is standing, and that's, does the plaintiff have standing to sue? In general, I would say, I always used to joke that anyone who ever shook hands with the landlord has a right to bring an eviction case in New York. It's a fairly exhaustive list. It doesn't just have to be the landlord, but it's good to check the ownership to see if the plaintiff has standing to sue, especially if the building's recently been sold. I've gotten out of a lot of cases in the past where the building will be purchased by an individual or by one LLC, and then they'll sell it to themselves as another LLC, but they will have commenced the cases under the initial name and they've lost the right to bring the case at that point. And you can either get it kicked or make them waste some time bringing a motion to amend their petition. So check Acris to see who actually owns the building. You can check the HPD website. We'll get into how to access those later. To see who the managing agent is and double check that the person who's suing actually has standing to bring that lawsuit. And if the tenant gets wind that the landlord is losing the building in bankruptcy or foreclosure, it's good to keep an eye on those cases. A landlord can unfortunately still sue for eviction while being foreclosed upon, but if that judgment is entered, they'll lose that right. So you may want to be keeping a close eye on the foreclosure case that's pending if your client's being sued by a landlord who's dealing with that. Going back to one of the first things we said, are all necessary parties named? If there's John Does and Jane Does named in the petition, are they adults, and should the landlord have known their name? This happens all the time. I don't think there's a ton of communication sometimes between the owners and their staff and their attorneys. And so the attorneys will just check the rent rolls, just name the named tenants, and then you come to find out, you know, the named tenant is the 85-year-old grandma, and it's actually the 25-year-old who's had every kind of interface with the building. And if they're not named, you can potentially get the case kicked, at least make a motion to slow it down. Failure to plead regulatory status is a big one. Again, all of those, all the different housing types we talked about earlier, that has to be specifically stated in the petition. The landlord has to give notice of what kind of housing it is. Rarely do you see them forget to plead rent stabilization status. But landlords often don't plead those specific regulatory agreements. And so if you find one of those on Acris, that can be a good way to get the case thrown out. And then disputing the allegations. Are there incorrect amounts sued for in a non-pay, or are there allegations that don't fit reality in a holdover? And that can be as general as, I paid them, I don't know what they're talking about. Or it could be something a little bit more specific. Landlords are, in terms of the 14-day rent demand, they are given fairly wide latitude to, in terms of the amounts and the months that they're allowed to claim. They're allowed to use what's called FIFO accounting, first in, first out. So a lot of landlords will wait until a certain number is owed to bring the case. That way it's worth their time to pay their attorneys. If a client is missing a month here and there, but otherwise able to pay, you know, a landlord might wait a couple of years to get that onto a rent demand. Just the fact that they'll generally claim that it was the last 5 months that are owed, even if those 5 months are sprinkled over the last 2 years. That's probably not a defense because they're allowed to use that type of accounting. But if they're giving incorrect amounts, if they're not being specific, they can't make lump sum allegations. They do have to break it down by monthly amounts. All of that can be a defense. And then with the holdovers, again, if your client disputes that any of this is going on, that can be a defense. And I think, yeah, we're going to get into more specific later, sorry. And then right now, pandemic specific, I don't think they're taking any new applications right now. So this is a defense that's coming to an end, but if your client filed for ERAP, that is supposed to stay the case. So at the moment, if an ERAP decision is still pending, that may stay the case. Different judges interpret that differently, so we won't get into the specifics, but it's a good thing to ask a client about if you're doing an intake and make sure it is brought to the court's attention. So more specific, non-pay. So did the client receive a written rent demand? As of 2019, all rent demands have to be made in writing. Prior to that, they could be made orally. There was a window of time from probably 2019 till the pandemic when some landlords weren't used to that and were messing it up and still trying to make oral rent demands. That was an easy motion to kick. Now you're almost certainly going to see, they're almost certainly going to be made in writing. And so the only question is, did your client get it at all, or did they fail to serve it? Does the client have any rent subsidies? An important distinction here between Section 8 and any other subsidy they're receiving. If it's a Section 8 tenant, they can only be sued for their portion, and then it's between the landlord and Section 8 to fight over any outstanding amounts that Section 8 is not paying. Any other subsidy, your client is still on the hook for it. So even if the city messes it up, your client still technically owes that. Amount claimed correct. Are there any repairs? A client is entitled to ask for a rent abatement, an offset in money that's owed for any conditions that existed. You're going to want to know, did your client give the landlord notice? Did they call 311? If they called 311, that's great. I'm speeding up a little because I'm realizing I'm running short on time. I don't want to keep moving here all day. If they called 311, HPD can list out the violations. That's some pretty concrete proof that the landlord got notice because HPD sends them out. So always ask that, always check the HPD website. Multiple dwelling registrations. A landlord's only entitled to collect rent if they have a valid current MDR. Rarely does a landlord just flake on this obligation forever, but they have to renew it every year, and a lot of them will let it go a month or two. And if you're in that window, that's a motion you can make. Certificate of occupancy issues. Obviously, if it's an illegal apartment, they may not be allowed to collect rent on that. If there's some giant safety hazard in another unit that could theoretically affect your client, that may be a defense as well. And then the Tenant Safe Harbor Act. If your client experienced pandemic-related hardship, a certain amount of months may be non-possessory, so they'll still owe it. They just can't be evicted for owing it. In a holdover, so time frame. In terms of the predicate notice, if a client lives in a building for up to a year, they have to get a 30-day predicate notice, 1 to 2 years, 60-day, and over 2 years, 90 days. So is the time frame that they were given correct? And then was your client entitled to a notice to cure? Sometimes a landlord will allege that there's nuisance behavior. If it doesn't rise to that level, you can say it's just a lease violation. They should have been asked to give a cure period. Vitiation. If a landlord accepts rent in the time period between when the notice to terminate legally terminates their lease and when the case is filed, that vitiates that notice and they have to start all over again. Most landlords won't accept rent until the court orders them to, just to be safe. Most landlords will file the day after the notice to terminate terminates to make that window really small. But sometimes it's a couple days. Ask how they paid rent. A landlord is unfortunately entitled to accept the check and not cash it until after the vitiation window ends, and that won't, they're allowed to do that. But public assistance checks are earmarked for specific amounts of time. Holding those won't, so you want to know how the rent is actually getting paid. New lease offers. Sometimes a landlord will terminate a lease, and then because they have a giant operation, someone will make a new lease offer, client will sign and accept it. They have to get rid of the holdover. Those kinds of oversights do happen. Waiver, that can get fact specific in terms of objectionable conduct. But what's concrete is the pet waiver. If someone openly and notoriously harbors a pet for 90 days, they can't be sued for having it later. Contradictory allegations or case theories. You see a lot of landlords, if their attorney is not a traditional landlord's attorney and maybe a first timer, they'll bring holdovers for non-payment. There's something called a chronic rent delinquency holdover about long-term patterns of non-payment, but you can't bring a holdover just for not paying rent. You see those, you can throw that right out. Have the alleged conditions already been cured? So cure, you're able to cure most lease violation cases. And so if your client says, yeah, I did have a roommate I wasn't supposed to, but they left 2 months ago, that's obviously a defense. And then is the housing type incorrectly identified? There's something called de facto rent stabilization. If the landlord claims it's a market rate, but you can show that at some point there was 6, or it's been illegally subdivided to be more than 6, or at some point it was combined with the building next to it, there's 3 in each, it makes 6. Then your client might be entitled to be a rent stabilized tenant, which would get rid of any no defense holdover. And then we're just going to finish and then leave a little bit of time for questions. I'm sorry it wasn't more, with some helpful tools to look at. One is Acris. Again, that's the Department of Finance's lease recording, deed recording system. HPD Online has a list of any violations and complaints that were made. It also shows the MDR status and any managing agents who are registered. Department of Buildings, the building information system has information about C of Os, boilers, when the building was built, violations that are placed, vacate orders, NICEF and eCourts we talked about. And then justfix.nyc has a who owns what is the name of it. Not every building in New York is on that yet. It's generally just the bigger landlords, but it's helpful to just search your building address on justfix.nyc, because if it is in their system, it'll give you links to all of the above websites, as well as show you other buildings your landlord owns. It's a good like one-stop search instead of having to go to a million websites. And then something about right to counsel. Anyone who is at or below 200% of the federal poverty guidelines is entitled to free representation through the city's right to counsel program. If your client has an active PA case, they automatically qualify, so you don't have to get too deep into the income, into what their income is. They're currently a little bit understaffed due to the COVID-19 pandemic, so many clients are being turned away, unfortunately. This is a central hotline you can have people call, or you can email OCJ. It's the Office of Civil Justice at HRA, who funds the program, to make referrals or to try and get your client connected with a housing attorney. All right, so if I have any questions, sorry that went a little longer than I planned, but if anyone has questions, please, now's the time.
Jim, can you talk a little bit, you highlighted all the different defenses, which was great, but can you talk a little bit about how some of the defenses result in dismissal with prejudice and others without? Because obviously, if a case comes back, it makes a big difference.
Yes. So that is, I think, was the most frustrating thing about practicing in housing court, is there is no double jeopardy protection in the way that there is in criminal court. Most of these technical defects will result in a dismissal without prejudice, meaning the landlord can just correct whatever that error was and try again next month. Still good to make motions and get those dismissals, because time is money, and if your client needs to get money together to pay the arrears, time is invaluable. But that is something to set client expectations when you're doing that. Say, we'll get this case kicked, but they'll probably, now that we've brought this error to their attention, they probably won't make it twice. They'll probably be back. Other cases can be dismissed with prejudice, which is, again, they just don't have the right to bring it back. If, I'm thinking like collateral estoppel decisions, things like that, affirmatively showing that money was paid, they can't sue for that rent amount again. Things like that. I also just wanted, I said we wouldn't get too deep into how to practice housing law, but I think it's good to give a quick explanation of how answering a housing court petition looks. Basically, a client walks up to a window and just tells their story, and then someone at a computer checks whatever boxes they deem to be relevant. So again, I think a little bit of research, a little bit of issue spotting before you send your clients in to answer is good, because if they don't bring a thing up, it's not ending up in that answer. If they miss it, again, you can make a motion to amend the answer later to include those defenses. But the more prepped you can have your client to go tell their story at the answer window, the better that initial pro se answer is going to be.
So James, just one note on Section 8 tenants. So I used to do a lot of work for NYCHA, and actually, if for some reason the tenant is disqualified or their eligibility for subsidy is in question or in incapacity, the landlord can also sue for the full amount of the rent, not just their portion. So they're eligible to sue them for the entire amount, not just including the subsidy amount, because they'll be sued for NYCHA to recoup that amount.
Yeah.
Jimmy, let me join in on this. That may be the case, right? If somebody in the past received the Section 8 subsidy, that subsidy was terminated and it was properly terminated. Then there no longer is a tenant's portion and a Section 8 portion, and all was the tenant's portion. Depending on and this is getting into the weeds, depending on the type of Section 8, depending on which agency is in charge of Section 8, the landlord actually has some requirements to put Section 8 on notice that they're going to be bringing a case against a current or former Section 8 tenant, depending on how former they were. something called the Williams Consent Decree. And so NYCHA has to say, yes, you are suing for the right amount, or no, we object to this because you're not suing for the right amount. You know, and then there's certain protocols that the landlord has to follow if NYCHA does object, and actually bringing them in as a respondent is one of those requirements under the Williams Consent Decree. And this is actually why that pleading requirement about what is the regulatory status is so important. You know, it's a super high volume court, and you know, judges will see dozens, if not, you know, potentially 100 cases in a day. And they need to be able to look on the face of the pleadings and see what they're dealing with, right? And as Jim went through it, you could see, you know, there's so many different types of housing. The different types of housings have different rights and responsibilities and defenses, and you know, getting that information up front in the petition really does bring a lot of sunshine into the process.
Yeah, I would also add depending on how and when Section 8 subsidies were terminated, there's a number of like kind of out of the pan into the fire defenses you can make in non-pay cases. One of them is, you know, this was Section 8 money, I was terminated, you're supposed to bring a holdover to terminate my tenancy, not sue me for this money. It may be in your client's best interest to just pay the market rate and not be evicted. Same thing with any number of you know, breakdowns in the contractual relationship in a non-pay. It may not be worth it for your client to speak up and say, I don't actually owe you this money because I'm not really a tenant and you should be bringing a holdover. So, you know, there are legal defenses and then there's practical realities, and you may want to settle away from those or not bring it up, or, you know, sometimes even pay money that you'd be able to argue your client doesn't owe otherwise to get a favorable settlement.
All right, are there other questions? Yeah, we could also get in, you know, we could do a whole lunch and learn on Section 8 in great detail. I see somebody unmuted. Maxine, did you have a question?
Yes, will the presentation be distributed? Will we get a copy of that?
Yeah, sure. We'll have it posted on our pro bono library along with the recording. And I think we'll probably be able, we could send the deck out to the folks that were registered for the training as well.
Okay. And what are our next steps? Like, when will we be getting involved? Like, what do you expect us to do next?
Good question. I mean, it depends on what firm you're at. So, you know, we did this lunch and learn as part of our children's project. That is a defined number of firms that have partnerships where we partner with schools and healthcare providers in the community, and you know, do clinics and intakes through those partnerships. Okay. If your firm isn't one of those law firms, there isn't a pro bono opportunity here. We did send it broadly out, and happy to, you know, have other pro bono partners be a part of the training and get the information. And so check with your firm to see if you're one of the ones that partner with laws on this.
Okay, thank you.
All right. Well, again, thanks everybody for joining. Thank you so much, Jim, for leading this training. And looking forward to working with folks on these cases and all the other cases that Vols does with our pro bono partners.